Welcome back to Understanding Tribal Treaties and Reserved Rights. In our previous episode, The Unique Status of Tribal Nations, we explored the rich tapestry of tribal sovereignty. In Treaties, the supreme law of the land, we dove into the historical significance of tribal treaties. In today's episode, Beyond the Paper, the power of reserved rights, we'll unravel the concept of reserved rights. By the end of this episode, you will be able to explain reserved rights and their role in safeguarding tribal resources and cultural heritage. As a reminder, we are grateful to the tribal leaders who have joined us to share their own and their tribe's experiences and views. And note that these tribal leaders are speaking as representatives of their sovereign nations and not providing the views or opinions of the federal government. In Episode 2, we discussed that from 1778 to 1871, the United States' relations with American Indian tribes were defined and conducted largely through treaty making and the implementation of those treaties. Through these treaties, Indian tribes ceded or relinquished land, resources, and other rights or interests to the United States in exchange for certain rights, land, payment, goods, and services. The terms of these exchanges were laid out in the treaty, but as we'll talk about in this episode, the rights that some tribes kept or were given include more than is apparent in just the written words of a treaty. Sometimes we have to look at what was not said to fully understand the rights that tribes hold under their treaties, what was reserved by the tribes.
So what exactly are reserved rights and why do they matter? Reserved rights can include implied rights that were retained by or reserved for tribes. The key word to remember here is implied. These are rights not specifically mentioned in the text of the treaty, statute, or other document. They are rights found in the overall context of the document, which are understood in light of the history and circumstances surrounding the document and the background legal principles. Reserved rights are not limited to treaties and can arise based on a statute, executive order, or other law.
But they said, in this territory we're ceding, we're going to maintain the right to hunt, fish, and gather. And so to this day, they are able to exercise those rights. And a lot of people feel that those rights are special rights or rights that have been granted to the indigenous people by the federal government. And some misinformed people even feel they're granted by the state government. But that's simply not the case. And that's something that I would hope that all federal employees know and realize, is that when we're talking about treaty rights, we're talking about rights that are inherent as the indigenous people of this continent that had those rights that they were exercising prior to European contact.
Reserved rights can include implied rights, but that does not make them any less binding or enforceable. Implied rights are just as important as express ones. The Supreme Court first recognized reserved rights in United States v. Winans, a case in which a private company had blocked a tribe's access to its traditional fishing grounds. The Treaty of Yakima in 1855 provided for the tribe the right of taking fish at all usual and accustomed fishing places. The Supreme Court interpreted the expression, right of taking fish, to mean that because the tribe had an express right to fish at their traditional fishing grounds, it must also have the implied right to access those fishing grounds, even across privately owned land. Though the treaty did not expressly address access, history showed that the tribe had enjoyed access to the fishing grounds at the time it entered into the treaty. The Winans decision has been quoted in many court opinions since. In it, the court explains that treaties are not a grant of rights to the Indians, but a grant of rights from them, reservation of those not granted. In other words, tribal rights that were not expressly granted to the United States at the time of the treaty could have been retained by the tribe. This is known as the implied reserved rights doctrine. It's important to know that the implied reserved rights doctrine extends beyond pre-existing rights and recognizes that treaties, statutes, executive orders, or other formal documents also implicitly establish new rights as necessary to carry out the purposes of the legal document. In Winters v. United States, another foundational reserved rights case, the Supreme Court held that a right to water was implied to be reserved in an 1888 agreement establishing the reservation as a permanent home for several tribes. At issue in the case were the upstream irrigation works of non-Indian farmers, which had prevented the downstream flow of water to tribes on the Fort Belknap Reservation.
While the 1888 agreement establishing the reservation didn't explicitly mention water, the Supreme Court held that an implied right existed based on the reason for which the reservation was established, that is, to provide a permanent homeland for tribes and to promote their development of agriculture. The reservation's land, which the court found was arid, would have been practically useless for agriculture without water. For that reason, the court recognized the agreement established an implied right to water as necessary to fulfill the purposes of establishing the reservation. The rights addressed in Winters, reserved water rights, now also called Winters rights, provide a good example of what we have been discussing. That rights reserved in treaties continue to this day, and that treaties, along with the Constitution and federal law, are the supreme law of the land. Courts regularly recognize that tribal reserved water rights, which can either be created when a reservation is established or predate a reservation's establishment, take precedence over water rights established later in time. The Supreme Court has recognized reserved rights for other purposes as well. For example, where a treaty reserves or grants lands to a tribe, the Supreme Court has held that tribal ownership necessarily includes the full right to hunt, fish, and gather on those lands, even where the treaty doesn't expressly address hunting, fishing, or gathering. The enforcement of reserve rights can be important to the cultural survival of Indian tribes and protection of tribal natural and cultural resources. Again, reserve rights are not necessarily expressly written, so it may not always be obvious from the text of the treaty, statute, executive order, or other law what they are in a particular case.
Agencies should also bear in mind that tribes generally retain rights to own and use lands and resources that have not been conveyed or expressly granted away by treaty or other federal law. Tribes also have rights necessary to fulfill the purposes of a tribal treaty, statute, executive order, or other law. Topics like these are complex, and it can also be complex to determine whether other statutes or legal documents may have affected reserved rights. When working on issues that may impact tribal treaty or reserved rights, you should always seek advice from agency's legal department. You should also engage in tribal consultation. The tribe may have more readily available access to documentation, knowledge, resources, and other information relevant to their reserved rights.
That wraps up our exploration of reserved rights. Now you should be able to explain reserved rights and their role in safeguarding tribal resources. We've journeyed through tribal sovereignty, delved into the historical significance of treaties, and now uncovered the critical role of reserved rights. Join us next time as we explore the contemporary relevance of tribal treaties, sovereignty, and reserved rights in various fields. Until then, keep learning, keep engaging, and remember, knowledge is a powerful tool for fostering effective federal-tribal relations.